Good morning. My name is Jennifer Gray, and I want to thank you first of all for tuning in. The purpose of this presentation is to review my critical analysis of the topic of due process. Let's start by defining due process. Due process is defined as a formal way to resolve disputes within a school. Now, this may involve students and or teachers, and we will discuss that just a little bit later. But this process reviews the Equal Protection Clause of the 5th and the 14th Amendments. Now, the 5th Amendment applies to federal, while the 14th Amendment applies to the states themselves. This process may involve an impartial hearing officer, and we will discuss that in just a few minutes. Who can file a complaint? First of all, students who feel they are deprived of their rights to education through disciplinary action may file a complaint. What this refers to as far as students and disciplinary action, these are students who may be facing either suspension or expulsion. Under the law, they do have the right to due process, and they do have the right to a hearing as a result of those disciplinary actions. Also, students with special education disputes, they are also entitled to due process, as well as tenured personnel. This includes both certified and classified personnel. What's considered in regards to a due process? In other words, if for a person to file those claims that feel that that clause has been violated, there are two things that we typically look at. The first being substantive aspect. That means, is there a valid reason for depriving an individual of their rights? And the methods must be reasonable in that case. And we're going to discuss a couple of cases, a few slides down, that does give some examples of how the court feels in this regard. Procedural aspect is another thing that must be considered when reviewing due process. Is the individual deprived of life, liberty, or property due to the lack of notice and the ability to be heard? And finally, there are two other areas or two other aspects that the court must consider when they are reviewing cases. These two aspects involve the vagueness test. How vague is the action that's being taken? And the presumption test. Let's talk about substantive and procedural due process, though. Substantive due process. This examines the justification underlying the law. It challenges that the law should be voided for everyone. Now, I have listed two different cases. Both of these have a tremendous impact in the world of education. The first is Meyer versus Nebraska. This was a case heard by the U.S. Supreme Court, and it was based on a law that was established in 1919 by Nebraska, and the law basically restricted foreign language education. The U.S. Supreme Court did hear this case, and they did find that it was in violation of the Due Process Clause of the 14th Amendment. The second case that involved a substantive due process was Goss versus Lopez. Again, this was heard by the U.S. Supreme Court. The court upheld the case that the public school must conduct a hearing before subjecting a student to suspension. The court ruled that a suspension without a hearing violated the Due Process Clause of the 14th Amendment. I know a lot of schools in my area, such as Huntsville City, as well as myself, the system I currently work in, Madison County, we are actually working with the Department of Justice because of situations that may have resulted in cases being filed against the system. And one of the things the Department of Justice has looked at with us is this particular case itself. along with Huntsville City. Both Huntsville City and Madison County have had to revamp their discipline policies to ensure that there was a due process in place when suspension and expulsion were involved. Since I work in Madison County, I'll talk a little bit about our process itself. For us, when a student is referred to the office for a disciplinary action, if we have our discipline broken down into various levels, as many other systems do, and we have started making sure that we do progressive discipline. In other words, we start with the lowest level and we build up from there. If a level gets to the point of a class 2, 3, or 4, it could involve suspension and expulsion. In this case, we must give the student their due process. So when a student comes into our office, we ask the student to write out their side of the story. If they list witnesses, we talk to all of those witnesses, as well as teachers that might have been around or administrators. If suspension goes to the point that it may involve referral for alternative school or change in placement, we do have hearings in place. We have a hearing officer that is impartial, as I mentioned before, and that hearing officer meets with the students, with the administrator that's making the referral, and with the parents. They listen to both sides, and then they make a ruling based off of our disciplinary action. There is also an appeal process that goes to our board. Again, that's just another level that involves an impartial hearing. And all of that is due to situations that can be traced back to even this case of Goss versus Lopez. The other type, procedural due process. This process challenges the government to apply law or policy specific to an individual. This challenges that the law deprives that person of life, liberty, or property without proper notice and an opportunity to be heard. Two cases that I have listed in this PowerPoint that fall under the due process of procedural, Brown versus the Board of Education of Topeka. This was a landmark case heard again by the Supreme Court. The court ruled that the American state law establishes racial segregation in public schools are unconstitutional, even if the schools are otherwise equal in quality. The court said that that is not permissible. Another case, Smith versus the School City of Hobart. The court ruled that students' grades could not be lowered due to a disciplinary action in order that the grade be readjusted for, in this case, a student named Smith. Again, I'm going to refer back to my system. In my system, if a student is suspended, they are allowed to make up their work, and part of that stems from cases similar to this with Smith versus the School City of Hobart. It's considered more or less to be a double jeopardy kind of thing. They cannot be penalized for not doing work that they may have done if they had been allowed to come to school. So that is why we have changed our policy, and many other schools have done the same. In my research, I have discovered that most of the cases do relate to either primary or secondary education. A lot of the articles that I read focused on the impact that it had for those students. It also discussed the impact that it had on their understanding of what the process is. And that is one thing that we do try to do in my system. We do explain to a student what their rights are in regards to due process. And before we get them to write a statement, we try to explain why we're having them write that statement, that is part of their due process procedures. But as I was doing my research for this project and reading articles, I noticed not a lot was said about students at the post-secondary level. I did come across a couple of articles that discussed the increase in the number of cases that have been filed. One of those came from the Washington Post, and it talked about that there is definitely a rise in the number of cases being filed at the post-secondary level. That there was one number thrown out that it was almost one case per week is being filed against universities. Many of these cases, however, although there has been a judgment at the lower cases, there have not been any state level or federal level rulings as of yet. And that is because a lot of them are still going through the appeal process. And a lot of them, after the first hearing, are even being settled. So it will be interesting to see if any of these actually make it all the way up to the Supreme Court. This concludes my presentation. I will share some of these in my citations. There's some of my court cases that I've mentioned if you'd like to read more about those situations, and a couple of the articles that I found very interesting as far as student perceptions and studies and things like that. Again, this does conclude my presentation. I hope you enjoyed it. I thank you for listening.